students who share the link to these sessions with persons who are not registered with the institution. Please, we ask you not to do that, as it puts everyone at risk. And also, you have people who are not supposed to be on these platforms who are here. So we ask you very nicely, please do not share what is happening here with other persons, unless you have a very good reason for doing so. Right. Last night, we ended off with jurisdiction. And today, we are going to continue with jurisdiction to conclude what we have not been able to deal with last night. You won't see my face this evening because it interferes with the bandwidth. Our load shedding seems to be back again on a more regular basis, and it affects my network as well. So sorry to disappoint you. You won't be seeing this ugly face today. Today we are going to start off with the parties to a pleading, and we're going to start with the summons. The summons is a document which a party uses to institute action proceedings. Very important that you distinguish between an action and an application. But for our purposes today, we are starting off with an action. Now, collectively, you have in an action a plaintiff, who is the person instituting the proceedings, and you have a defendant, who is the person citing as the person to be held liable, or the wrongdoer, if you want to call it that. You also have, in terms of Rule 2, Sub-Rule 1 of the Magistrates' Court rules, an applicant and a respondent. Now, these four persons have been described as the litigants in any action or application for that matter, because we're now talking about an applicant and a respondent. That refers to an application. Collectively, these are referred to as the parties, not the ones that you vote for on election day, not the ones that you go to and dance to nice music, but a party is referred to as a person who is a litigant. Rule 2 Sub-Rule even goes further to say that these things will even include the attorney or the advocate who is appearing in court on behalf of those persons. When you present a litigant, be it a plaintiff or a defendant, I or we, you will refer to that party at all times. Only when the court directs something specifically to you may you use the word I, and also in appropriate circumstances only. But the party that the person that represents, the legal representative that represents that party, is also referred to as a party to the proceedings, in a technical sense, not in the real sense of the word. Now, The rules are very specific. Remember last night I told you that whenever you are dealing with magistrates court's practice, you will have to have the rules of the magistrates court in front of you to guide you. And this will also, when we do case management in the near future, hopefully I will be taking you, and you will need to have your rules with you, because when you draft documents like pleadings and affidavits, like you will be doing in the casework, you will need to have your rules with you at all times. Rule 5, sub-rule 4 states specifically that in a summons, the following must appear. Never mind the fancy language every summons shall set forth. In every summons, the following must be there. First of all, the surname and the first names or initials of the defendant by which the defendant is known to the plaintiff. Now, this is very important. It first says the surname and first names. It's important for you to establish the real and the full and proper names of a defendant or a respondent if you want to sue someone. But we are talking about a summons here, so it's a defendant. We're not referring to a respondent yet. So when you cite that person in your summons or particulars of claim, you must fully describe that person. The defendant is Johannes Jacobus van der Merwe. Those are his names. Now, here's an example. You don't know the full names of the defendant. You've not bothered because you know he's JJ van der Merwe. So you issue summons against JJ van der Merwe at his address where he resides. The sheriff gets to this household and he asks to speak to JJ van der Merwe. And there to the door come running 7 little persons and 3 adults. Yes, I'm JJ van der Merwe. Conundrum. Which JJ are you looking for? So try by all means, as much as possible, to get the full names of the person whom you want to cite in a summons. It's important then further that there must be in the summons that defendant's residence or place of business. It's known the defendant's occupation and employment address. And if the defendant is sued in any representative capacity, what capacity is the defendant being sued in? And lastly, the full names, the general, if the plaintiff is a natural person, and the occupation and residence or place of business of capacity, such capacity. So in terms of the plaintiff, who is normally cited first, you must follow those rules. And in terms of the defendant, the exact same rules apply. You must follow the exact same rules by citing their full names, their address, business, where they are employed, as much as possible. Most people prefer, most attorneys I know, prefer to just cite the defendant as the address where they reside, and that's it. If you know where the person resides, put it in the summons, because if the sheriff is unable to find that person at their place of residence, they can go look at work, and the address is there. And you'll find that the sheriff's office act according to strict instructions only. If you send the sheriff to that person's residential address, they will only go there. And if you want them to go to that person's business address after they've been to their personal address and it's not in the summons, they will ask you to amend your summons, excuse me, or give them a written instruction to go to a different address, and they will charge you extra. And believe me, the sheriff is not shy to charge a fee. Their fees are exorbitant and unreasonable, but it's up to you, the legal practitioner, to point that out to them that they are being unreasonable and they are charging too much money. There's a tariff to which they must adhere, and that must be enforced at all times. Now, Rule 6, Sub-Rule 12 of the Magistrates Court Rules stipulates that where the plaintiff sues as a cessionary, in other words, a benefit of a contract has been ceded to the plaintiff, and the plaintiff is not cessionary, in other words, the holder of these new rights, or the new holder of these rights, the plaintiff must indicate the name, the address, and the description of the person who ceded those rights to them, as well as the date of the cession. Another requirement of every summons is that, and I've just said so, it must set out the plaintiff's details. And normally the plaintiff's details are set out first, so that which makes sense, so that the defendant knows who is suing him, her, or it. You'll notice I said him, her, or it, because the it refers to a juristic person, and a juristic person is a company or a closed corporation. You do not sue the directors or the shareholders of a company. You sue the company. The company has legal capacity, and you are able to sue and be sued by a company. Of course, that company will be represented by its directors if they need to either sue or defend an action against the company. And the rule 6 is also specific as to how you must cite a juristic person. For instance, a company, you will say the plaintiff is ABC Pty Ltd, a company with limited liability, duly registered and incorporated in terms of the legislation of the Republic of South Africa, with registered address and principal place of business at 111 Naidu Street, Pretoria. That's how you describe a company. The plaintiff, in the case of a closed corporation, is ABCC, a closed corporation duly registered and incorporated in terms of the Closed Corporations Act, with registered address and principal place of business at 111 Naidu Street, Pretoria. Fully described and as much information set out as possible. Now, the same will apply with when you are putting your facts into the particulars of the summons and the particulars of claim. You will need to disclose as many facts as possible for you to sustain a cause of action. Yes, it is going to go to trial for oral evidence, but as much information as possible is important in your pleadings for, and you will see that later on, when an exception is raised, an exception will be raised because you didn't disclose the action, rather on the side of caution and facts rather than less facts. The educational institutions in our republic, especially higher education institutions such as universities and colleges, these are established in terms of the Higher Education Act 101 of 1997. And they are also autonomous entities or legal persons with locus standi to be sued and or sue. in their very own names. Public schools are also juristic persons, but in that case, when you are suing a school, you must sue the governing body, the school governing body of that school. Private have boards of directors, and they are also juristic. Lindy,
Good evening, Advocate.
Lindy, can you meet?
Good evening, Advocate.
Good evening.
Hi, Advocate. You're speaking to Leslie. I'm unsure if it's only me, but the audio seems to be a bit bad tonight.
The audio.
Yes. Oh, I see here in the chat. Some people are also saying the audio is a bit bad tonight.
Yes.
Perhaps you could just log in and out if it's not too much trouble, because I keep losing you, Advocate.
Okay.
Thank you.
Thank you for that. I'll look into it. Lindy, would you like to say something? Zukiswa, can you please check with IT if there's perhaps a sound issue coming from somewhere, because my settings are all fine.
No, I think it's network, Advocate.
Network because of load shedding.
Yes, I think so. We can hear you now. I can hear
you
you
hear me?
clearly. I don't know others. Yes, we can hear you.
Okay. I will try to speak louder. I think it's not everyone experiencing issues with sound.
Yeah.
Okay, we'll carry on, and if it gets really bad, and if we get many more complaints about the sound, then we'll see what to do. Okay. Thank you. Married women. Married women, 1904, did not have the rights that they enjoy now, because they could not do anything, and this is married women in community of property. They could not do anything without the written consent of their husbands. However, since the Matrimonial Property Act came into existence in 1984, women were now deemed equal to their counterparts and have been given rights to contract on their own. However, whenever you enter into any legal contract, you are married in property, contracts that are cumbersome and that, for instance, the transfer of a property or the purchase of a property, if parties are married in community of property, both parties need to consent to the sale of that property. Both parties also need to sign the documents in order to complete the legal status or the locus standi of that transaction. Still bad, sound still breaking up. I don't know what I'm going to do about this. I don't know. Okay, I'm going to carry on because then you can tell me if there's any difference as I go along. Minor children do not have locus standi. Do not have locus standi to enter into any legal transactions, let alone sue or be sued in their own names. A minor child under the age of 14 years. In criminal law, we say that child is doli incapax, incapable of committing any wrong, incapable of appreciating the difference between right and wrong. And therefore, in civil proceedings, we say that child must be represented by their legal guardian, or which is normally their natural parent. And where that happens, then the parents will sue and have to be sued on behalf of that child. But it's very seldom that a child under the age of 14 or 18 for that matter is sued, especially under 14, because they don't know the difference between right and wrong. But that's a discussion for another day. We won't go into it too deeply. Now, children over the age of 14 and under the age of 18, because 18 is now the age at which minors acquire the age of majority. It used to be 21 before, but it's now been changed. So those children under the age of 18 but above 14 have to be assisted by their legal guardian or parent in any litigation, whether they are suing or whether they are being sued. So your summons will say, let's say you are suing on behalf of a minor child who is 16 or 15 years old. You will say, the plaintiff is John James, a minor child, a minor person, aged 16 years, duly assisted by Mary James, his mother and natural guardian, who is an adult person residing at 123 4th Avenue, Garsfontein, Pretoria. There you have cited a child now being assisted, a minor being assisted, but over the age of 14, under the age of 18 years of age. A person who suffers from a mental disability, in other words, is unable to comprehend right from wrong, or is just certified mentally disabled by a medical doctor. That person lacks legal capacity to sue and be sued. And I'm going to make an example, a practical example for you. A person was involved in a motor vehicle accident, suffered a serious brain injury, and as a result of that brain injury, is unable to manage his own affairs. We normally say that person will require a curator ad litem to represent them in legal proceedings because they don't have the legal capacity to represent themselves. So it's a curator ad litem. A curator ad litem is going to be the person who's going to represent that mentally disabled person, who's going to protect that person's rights, especially the rights to litigation. When they are litigating against the Road Accident Fund, the curator is going to be cited as the plaintiff on behalf of this person, who is now called the patient because of their mental condition. And after the appointment of a curator ad litem, when the attorney for that patient enters into negotiations with the Road Accident Fund or any other party who is a defendant or being sued, all negotiations will have to go through the curator ad litem. If there's an offer of settlement, the curator ad litem has to consider that offer. And that is why it's important that that curator ad litem can only be, in terms of the rules of the Magistrates Court, can only be an attorney or an advocate. So it's a legally trained person who's able to give them correct and proper legal advice. So if the Road Accident Fund makes an offer of 1 million rand for general damages for that person because of the accident, the curator ad litem must be able to look at the injuries, the seriousness, the nature and the extent of those injuries, and make a determination whether that offer of 1 million rand for general damages is a fair and reasonable offer in the circumstances. And if it's not, the curator must guide the attorney representing the patient as to what is a reasonable amount. Of course, relying on legislation and case law and the legal principles involved. This is not a fair offer. This is not a reasonable offer. Tell the Road Accident Fund, here are the cases. I've done the research. Here are the cases for these types of injuries. And these are the amounts that have been awarded to patients in recent case law. So tell them to either increase the offer to this or to a more reasonable offer. And offers don't necessarily have to match the exact amount that you want. When we negotiate higher for our clients. But you must have a settlement figure at which you can settle. If it says there was a case where a plaintiff was awarded 2.8 million rand for head injuries, there will be a distinguishing factor that puts your client on a different footing as that patient. So always be open to negotiations and settlements that are reasonable in the circumstances, but don't shortchange your clients when negotiating for settlements. Okay, that was digressing quite a bit. Okay, it gets more tricky when you have to cite a juristic person such as a partnership, right? Because it's not necessarily registered as a partnership, or it's not incorporated. And there, it will be sufficient if you are suing as a partnership to cite at least one or two, two or more of the actual partners in the partnership. As much as attorneys firms may enter into partnerships, they are still required to be registered in terms of the Companies Act. So that's a different partnership. But in terms of other partnerships, not necessarily legal partnerships, business partnerships, they are not always all registered. And where a party, where a partnership is not registered, you must at least, you have a mechanism available where you can compel them to disclose the names of the partners to you first. And after they've disclosed those names, you can either cite two or more of them in the summit. The same by if you are suing a partnership. Now the trusts, seen as a tricky legal person or a legal persona. In terms of the law, a trust is not regarded as having legal person. It can be, and the creditor of a trust, someone who is suing a trust, cannot execute against the assets of the trustees, the personal assets of the trustees. Only against the assets of the trust itself. And a trust estate can also be sequestrated if it is found to be insolvent. You've got to be careful when you're dealing with trusts because, and SARS has also now latched onto trusts. It was just the other day a directive issued by SARS dealing with trusts because a lot of people, what they do is they register family trust, then they register all the properties in the family trust on those items. SARS have now cottoned on to that, and they are coming after trusts because they know that people do that. They farms in trusts, they register the assets of that farm, the business of the farm, and the trust. So you've got to be careful when you advise your clients about trusts. And I always say trust is not my forte. Not wrong on that. And this is also very important for yourselves. If you do work in a particular field of law, or you've never done it before, make sure that you just 1 second, I need to check my connection. Okay, the sound is on now. Patrick, the sound was off. Is the sound any better now? Okay, Martin, I actually took a break to go and try and see what's wrong with my internet connection. Hopefully the sound is better now. It's on and off, yes, Justine. Sorry, like Eskom. Let's see what we can achieve with what we have. If there's anything at the end of our session that you may have missed, feel free to write it on the chat. I will see if I can get back to those questions. But let's try to see what we can achieve as much as possible. I will try to accommodate those who have not who missed out. But for now, let's just soldier on and see how far we can get. So be careful when you deal with trusts. I refer queries with trusts to someone who specializes in trusts. I stay away from things I don't know. You will be unpleasantly embarrassed if you try to do work in a field of law which you have no expertise, no knowledge whatsoever. So rather stay away from something that you don't know. Okay? Don't worry, Kanya, there wasn't much on partnerships and trusts, right? Right, now in an action, you can join as many plaintiffs to an action. There can be 20 people suing one defendant or 3 defendants. So it's not limited to one person, one plaintiff and one defendant only. You may join as many people as possible, provided, of course, the facts are the same. The law is similar. The issues in dispute are similar. And also the parties, it's very important that the parties are exactly the same parties. And by that, I mean, if it is 20 plaintiffs suing one defendant for the same cause of action, then you may sue them in one summons. What many attorneys do, though, is they will sue, and I'll make an example. 20 people took part in a protest with 500 other people. And those 20 people, the police came and then they fired rubber bullets or live ammunition and shot and hit 20 people. Now, these 20 people all go to the same attorney and they now want to sue the Minister of Police for assault by way of shooting. The attorney then decides these are 20 different clients of mine, and I'm going to institute 20 different claims against the Minister of Police against these persons. Lipeta, can you please mute your microphone? Thank you. So you should one in each name of one of your clients. It's basically a copy and paste exercise, except for their names and their addresses. And you are suing the Minister of Police for the same 5 million rands on behalf of each of those 20 plaintiffs. That can be done. However, the Minister of Police, now represented by the State Attorney's Office, will instruct the State Attorney's Office or whoever is representing them to consolidate those 20 cases into one action. Because the same cause of action, the same set of facts, the same parties, the same defendant. And for convenience sake, it is in the best interest of justice and all parties concerned that these matters are consolidated, because it's going to reduce the risk of confusion with different judgments, because not all 20 cases may be heard by the same judge. Let's say 10 of them are heard by one judge and 10 by another judge, or just individual judges. You'll have 20 different judgments on the same evidence of cases. There'll also be a multiplicity of court sittings for these cases, and there will also be a multiplicity of judgments for these cases, thereby causing confusion and inconsistency. So the argument of the Minister of Police as the defendant will be that it's going to be in the interest of justice and to everyone's benefit if it's done like that, if cases are consolidated into one case. And it's very rare. I've never come across a case where a court has refused to consolidate one case, one for convenience sake. So in a similar way to the plaintiff situation, you will also have a scenario where there is one defendant, and I'm making an example, a petrol attendant for a filling station puts into a truck petrol and diesel. Now, the motorist's vehicle is now damaged as a result of that. And the motorist decides to sue the garage because this person worked for the garage. You, as a sharp legal, you would believe that he did something unauthorized. You do not authorize our fuel attendants to put in the wrong fuel. So he acted on a frolic of his own, and as a result, we should not be held liable. He was negligent, not us. In that case, it may be wise for you as a clever attorney to join the petrol attendant as defendant from the get-go, so that you don't lose the opportunity of going after the right person if the court decides the fuel station is not held liable. During a trial, during an action, the person, let's say it was the father of child who was injured at school because they had an accident at school and died. The father, the school or the Department of Education for damages arising from that death of the child. It looks like out in full force tonight. After I said that the person representing, I did not say anything else because my screen froze on my side. But whilst the going, the parties are still exchanging meetings. The father of that child also dies. Sadly so. The mother of the child is still alive, and she now has to substitute the father of the child who is no longer alive. But if the mother is not alive, then the estate, the executor of the estate of the father.
Sorry, advocate, I apologize. Sorry,
that is what we call a substitute. So defendant may also be substituted as a party to proceedings. If for whatever reason the initial hello.
Sorry, advocate, I apologize for interrupting you, but the sound quality is really, really bad. And on our WhatsApp group, it's been throughout. Everybody is having the same problem.
Yes, it's everyone is affected by it. Yes.
Yeah, the only
I
problem
think it's
is
caused by the load shedding.
the only problem, Advocate, is
in
we're
full
only getting
force now,
snippets.
so I think we're all affected by it. Last night. Yes. Yeah. Okay. Thank you for that, Zuki. Are you here and are you able to assist?
I'm
Zuki?
here. I don't know.
Are you here?
I'm here, Advocate. I'm here. I don't know how
What
I
are-
can assist
What are we
if it's
going to
load
do?
shedding. If they want us to cancel the class, we can
I
cancel
think
it
it's low.
because it's load shedding. It's network problems. So if
My
they want us to
connection is
cancel,
fine. Yeah, it's not from my side because I'm using a high-powered fiber 20 meg internet Wi-Fi system, and I haven't had problems. Last night it was fine too. So I just
so
So
I don't know because I don't know if they want us to
the
cancel. We
signal
can
is being
cancel,
affected by
Advocate.
the load shedding.
Yes, it's load shedding.
Can we
So
cancel?
guys, do you want us to cancel or what do
Does
we do?
anyone have an objection to us canceling tonight's session because of this problem? Because we are
Is it
you know-
possible for the Advocate to record the class for us and have it uploaded on eLeader? Because right now we're only getting snippets of the class.
I beg-
Yeah, for only
But still-
today, for only today's session, it can be recorded, and tomorrow we can
Okay,
proceed.
guys. Okay, I'm sorry to say this, but I'm recording the session now. So if it's load shedding, still his recording will be the same. So he must just continue, and then we will upload this recording and last semester's the second day recording. Last semester's second day recording. So I think, Advocate, you should continue.
But Zukiswa,
we cannot hear.
We
yeah,
cannot continue if we can't hear.
We're continuing,
cannot
but
hear
we cannot hear anything.
and the recording, even if we get the recording, it will still come the same.
Yes, it will be the same.
Sorry, Zuki,
So
it
I don't know.
It
what
won't
you
help.
guys think.
It won't help for us to continue if we're only hearing snippets of the class. If it's going to be cancelled, then let it be cancelled, and then just share the recording from last year's session so that we can work through with that one. Because right now, we're just making
Okay.
things up as we're going, like in terms of what we're trying to do.
Okay, it's fine. Let me say this because there are some who say we must continue. So if you feel you cannot follow today because you are hearing snippets, it's fine. I'm still recording this session, and I will upload last year's session as well. I think Advocate should stay and continue. Those that do not have a problem who want to continue, then they can continue. But you are all free to leave. If you cannot go on, you can leave. It's fine. You will not be penalized.
If I may
I don't know what
respectfully
you think.
request, we've had problems before, and understandably, it's nobody's fault. It's just the way things are. Is it at all possible, if not putting the advocates and lecturers out, to record voiceovers over their PowerPoint presentation? So when you send the slides, that is attached with it to avoid this in future.
Okay, Advocate, I don't know. Would you like to continue or to end the session?
Zukiswa, I have my hand raised. Can you hear me?
Your transmission was and I couldn't hear full. But I'm trying to guess that.
I don't think I can hear the Advocate properly. His line is cutting.
Zukiswa, can you hear me?
Yeah, I think we should run. Okay, and I will speak now, okay? Because I think we need to make a decision on this issue, otherwise debating it the whole night. The decision is that we will not continue with the session, because if I continue now, those of you who can hear will probably be a handful too. So we will resume tomorrow. And we will see if we cannot start, if possible, at 5 o'clock, and then extend it by another half an hour afterwards to see if we can try and catch up as much as we can.
Thank you so much, Advocate. That actually really does help.
Thanks, Advocate.